to the virtual mini plenary session. There will now be an opportunity for silent prayer or meditation. Thank you.
House Chair.
Honorable members.
House Chair, my apologies. Swat, my hand is up.
Oh, I didn't recognize you, Honorable Swartz.
No, I just wanted to advise that I may have connection issues, in which case the Honorable Sukas will deliver the speech on my behalf with your permission. Thank you.
Welcome. It's fine, no problem. No problem, Honorable Swartz. Honorable members, before we proceed, I would like to remind you that the virtual mini plenary is deemed to be in the precinct of Parliament and constitute a meeting of the National Assembly.
Recording in progress.
For debating purposes only. In addition to the rules of virtual sittings, the rules of the National Assembly, including the rules of debate, apply. Members enjoy the same powers and privileges that apply in a sitting of the National Assembly. Members should equally note that anything said in the virtual platform is deemed to have been said to the House and may be ruled upon. All members who have logged in shall be considered to be present and are requested to mute their microphones and only unmute when recognized to speak. This is because the mics are very sensitive and will pick up noise which might disturb the attention of other members. When recognized to speak, please unmute your microphone and connect your video. Members may make use of the icons on the bar at the bottom of their screens, which has an option that allows a member to put up his or her hand to raise points of order. The Secretariat will assist in alerting the chairperson to members requesting to speak. When using the visual system, members are urged to refrain or desist from unnecessary points of order or interjections. We now go to the order of the mini plenary. We shall now proceed to the order, which is debate on vote number 27, Office of the Chief Justice Appropriation Bill. I now recognize the Honorable the Minister of Justice and Correctional Services.
Yeah, thank you very much, House Chairperson and the Chairperson of the Portfolio Committee, members of the Portfolio Committee, and members of the House, the Deputy Minister of Justice and Constitutional Development, other ministers present, the Secretary General of the Office of the Chief Justice. It is my pleasure to present to the House the budget vote for the Office of the Chief Justice. Significant events have occurred in the month of May in our nation. On the 8th of May 1996, the National Assembly adopted our Constitution by former Deputy President at the time, Thabo Mbeki, his speech titled, "I'm an African." That Constitution, which was adopted by the National Assembly, has been celebrated across the globe as a model constitution and beacon of hope for the advancement of democracy and equality. It is worth noting that former President Mbeki's statement, "I'm an African," still eludes today on our daily lives. Many of us, black and white, remain enchanted by a psychological construct of apartheid. Too many of us think that we can be defined outside of the African continent. We are Africans as I quote, "We owe our beings to the Queen Zinga of Angola, King Mansa Musa, to President Kwame Nkrumah, Samora Machel, and our very own former President Mandela. At times, the caliber of our leadership has had the pioneering effect of creating a new world order and influencing events across the globe on human rights, on issues of inequality, and various issues affecting the global community. We still speak of Palestine today, about the struggle of the Syrian people and many struggle of the people of the globe because of the pioneering work of our forefathers on human rights. Incidentally, House Chair, May is also the month in which the history recorded the passing of a South African academic, an African National Congress leader, a lecturer at the University of Fort Hare, and Botswana's first ambassador to the United States of America, and the envoy to the United Nations, Zakaria Kiudirleingi Matthews. It was Z.K. Matthews who was the intellectual engine room behind the creation of our Constitution. As we celebrate our Constitution, we also celebrate the judiciary in our country, which derive its authority from Section 165 of the Constitution. We are thankful to the crafters of our Constitution for the protections afforded to the judiciary to allow it to apply the law impartially, without fear, favor, or prejudice. I take this opportunity to extend warm congratulations and welcome to the Chief Justice Raymond Zondo, who was appointed the head of the Judiciary and the Constitutional Court by His Excellency President Ramaphosa, effectively from the 1st of April 2022. We look forward to working with the Chief Justice in our efforts to assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness in line with Section 1654 of the Constitution. The judiciary are the guardians of the Constitution. To advance the judicial support, we are tabling before this August House a budget of 266 billion rands for voted funds and a further direct charge to the National Revenue Fund of 1,122 rands for judges' remunerations. The budget comprises of the Office of the Chief Justice core programs, the Superior Courts, and the Judicial Education and Support are allocated 79.8% of the total budget. The budget cutbacks implemented since 2020-2021 financial year have reduced the 2022-2023 voted budget allocation of the Office of the Chief Justice by 144.4 million rands, which amounts to about 10.2% of the overall budget. The effect of this resource scaling back means that the compensation of 16.1 million rands, which amounts to about 13% of the budget of judges and salaries, has been reduced by 183.3 million rands for the 2022-2023 financial year. A 5.5 reduction to the operational budget has also been implemented, translating to an effective 28.3 million reduction. The prioritization of the national response to the COVID-19 pandemic over the past 2 years resulted in the scaling back of the budgets across government. The impact of these budget cuts continues to be felt today. Further, the country's economy has been adversely affected by the ongoing COVID-19 pandemic, and it continues to struggle to grow at the desired rate. However, most key indicators suggest that the country's economy is slowly mending, but the pace of recovery has been too slow to translate into a sustained recovery. As such, we must be innovative and develop new ways of operating under these constrained conditions for us to keep the courts operational. This is where Honorable House Chairperson, I usually say, vana va munhu va tsemelana nhloko ya njiya. Loosely translated to English is that children born out of the same family, they share the head of a locust. It sounds impossible, but it can be done. I've been told that this idiom is in all vernacular languages. The current budget constraints faced by the Office of the Chief Justice necessitate that it finds ways to address its expanding workload by doing more with less and ensure that it delivers the required services despite immediate challenges. The 2022-2023 financial year budget therefore considers these important factors and prioritizes measures to keep our courts open, whilst also ensuring the safety of court users and officials. The Office of the Chief Justice will continue to reprioritize its budget and operations to ensure that the delivery of core services, namely support to the courts, is not adversely affected by the above. The Office of the Chief Justice has put in place measures to ensure that its resources are not misused through fraud and corruption. One of the key priorities of the Office of the Chief Justice is embedding a culture of ethics within its ranks. To this end, the Office of the Chief Justice has established an ethics committee in line with the applicable prescripts. A crucial area of work for this committee is the monitoring of compliance relating to officials doing remunerative work outside the public service and officials doing business with the state. This year marks 10 years since the adoption by all parties in Parliament of the National Development Plan 2030. The NDP, which serves as an action plan for securing the future of South Africans as chartered in the Constitution. The Office of the Chief Justice supports the Judiciary in its contribution to Chapter 14 of the National Development Plan, promoting accountability and fighting corruption. To this end, the focus area for the Judiciary is in strengthening judicial governance and the rule of law. Honorable members, this focus area is fundamental in guiding the development of the strategic priorities as outlined in the 2022-2023 Office of the Chief Justice Annual Performance Plan, the APP. The Office of the Chief Justice 2022-23 Annual Performance Plan therefore articulates key priority areas which are central to improving the governance and efficiency of the department. They are as follows: implementing initiatives that contribute to broadening and improving access to justice and the services of the superior courts, ensuring an efficient court system, improving efficiencies in court administration through modernization of the system, processes and infrastructure, and implementing initiatives to address the impact of COVID-19 on the operations of the courts. The Office of the Chief Justice will also continue providing training to the judges and aspirant judges through the South African Judicial Education Institute, in line with the objective of Chapter 14 of the National Development Plan. Incidentally, Sanjay also marks 10 years since its commenced with its operations. To mark this milestone, Sanjay has identified several activities to implement. It has recently held an international webinar under the leadership of the then acting Chief Justice on judicial training principles, attended by 125 representatives from 18 countries, giving Sanjay a regional and international footprint. This is an achievement to be applauded. Sanjay is also working on a book on judicial training in Africa to mark its 10th anniversary. Other notable achievements by Sanjay are as follows. Sanjay published a journal on judicial education-related matters annually. To date, Sanjay has published 5 issues. The journal is available on the website of the Office of the Chief Justice. Sanjay launched an annual program called Human Rights Week for judicial officers during the first week of December. The focus of the program is on human rights-related topics such as HIV, TB, AIDS, and human rights, LGBTQI+, gender stereotyping, judicial wellness, socio-economic rights, refugee rights, and stateless children. in line with Section 51F of the Sanjay Act 2008, which determined that one of the functions of Sanjay is to render such assistance to foreign judicial institutions and courts as may be agreed upon by Sanjay Council. It has initiated projects in Africa and conducted the following training programs. Sanjay initiated the integration of environmental law into judicial curricula on the African continent. The initiative led to the establishment of the African Judicial Education Network on Environmental Law, launched in Maputo in 2018. Sanjay serves as a secretariat. To date, several institutions in Africa have produced training materials on environmental law, including on illegal wildlife trade. Sanjay has invited judges and magistrates of foreign judiciaries to its seminars and webinars. For example, members of the judiciary, especially judicial educators, were invited to a webinar on implementing training in the new normal times and how to conduct virtual hearings. The aim of the webinar was to assist in ensuring that training takes place despite the pandemic. Sanjay has successfully conducted training of newly appointed judges and magistrates in Botswana at the request of the Honorable Chief Justice of Botswana. In line with the objectives of Sanjay Act 14 of 2008, the Institute has called for applicants for aspirant women judges program in January 2022. It is envisaged that the training will be for about a year, including mentoring at various high courts. We commend the Sanjay for the sterling work it continues to do in ensuring the capacitation of not only South African judicial officers, but of judicial officers in other parts of our continent as well. Honorable members, modernization and digitization of the court system remain a key priority for the Office of the Chief Justice to improve access to quality justice for all. The use of technology to conduct online hearings has proved to be an effective alternative to traditional court sittings, especially during the challenging period of COVID-19 pandemic. The Office of the Chief Justice will continue to implement the court modernization strategy as a tool to enhance speedy access to justice. The Office of the Chief Justice priority of modernization and the use of technology will ensure an efficient court system that guarantees access to justice for all. During the 2022-23 financial year, the Office of the Chief Justice will continue to embrace and leverage on the new technology through digitization of the court system. The focus will be to prioritize court online and digitization of court records to enable the judiciary and the courts to continue adjudicating court cases through online platforms, even beyond the COVID-19 pandemic. The now fully developed and piloted court online system is meant to fully take advantage of the information and communication technology advancement to minimize not just the physical movement of people and paper based on court documents from parties to the courts, but also to leverage the benefits of electronic storage within the courts, faster documentation, filing and retrieval, eradication of the misplacement of case files, concurrent access to view the same case files by different parties. Over the medium-term expenditure framework, the Office of the Chief Justice will continue implementing the court online system to all superior courts as part of its ICT modernization initiatives. The judiciary has an important role in safeguarding and protecting the Constitution and its values, and ensuring the consolidation of democracy and the realization of a better life for all. It does this through its constitutional entrenched judicial authority. Over the years, the judiciary has shown a profound understanding of the constitutional imperative as set out to defend the basic law of the land. These include many judgments, particularly by the Constitutional Court, that have reflected a progressive interpretation of the Constitution and socio-economic rights in particular. In terms of Section 1654 of the Constitution, it is incumbent on the organs of state to assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. It is vitally important in a democracy that individual judges and the judiciary as a whole are impartial and independent of all external pressures and of each other, so that those who appear before them and the wider public can have confidence that their cases will be decided fairly, transparently, and in accordance with the law. When carrying out the judicial functions, they must be free of any improper influence. It is in this spirit that we table this budget vote today. The executive arm of the state is doing everything in its power to ensure that the constitutional enshrined independence of the judiciary. As the executive, we will be analyzing the judicial administration model with a view to give expression to a practical and functional expression to the nation of judicial independence in its administrative form. We call on this House to continue working with us to affirm the role of the judiciary in protecting human rights and advancement of democracy in our country. We must all understand that the judiciary are not in a popularity context. Their decisions must be respected or challenged within the available framework of the law. Chairperson and honorable members, I therefore present the 2022-2023 budget vote 27 of the Office of the Chief Justice for your support and approval. I wish to take this opportunity to recognize the Chief Justice Raymond Zondo, the President of the Supreme Court of Appeal, Justice Mandi Samaya, the Deputy Judge President Obreli Dwaba as the Chairperson of the Magistrate Commission, as well as the heads of courts and all members of our judiciary for their continued service to the people of South Africa. I also acknowledge the OECJ Audit and Risk Committee for the effective oversight role they continue to play. Finally, I thank the Secretary General of the Office of the Chief Justice, Ms. Meme Songwe, the management team of the Office of the Chief Justice and staff for continuing to serve with distinction. You can see, Kanmam.
Thank you very much, Honorable Minister. The Honorable Makwanisha from the ANC, the next speaker.
Thank you very much, Chairperson. Honorable Minister Ronald Lamola, Honorable Deputy Minister John Jeffrey, Honorable Deputy Minister Nkosi Phathekile Olomisa, Secretary General of the Office of the Chief Justice, Ms. Messi Josingwe, honorable members. Let me take this opportunity on behalf of the Portfolio Committee to welcome our new Chief Justice, Judge Raymond Zondo, and we wish him well in his new appointment. On the same token, let me also take this opportunity to thank the former Chief Justice, Judge Mogoeng, for his service to our nation. We wish him well in his endeavors. The committee welcomes the minister's announcement that he will introduce legislation in support of establishing a single judiciary. He also intends to bring proposals concerning a judicial governance and court administration model to Cabinet. The establishment of a single judiciary is a constitutional imperative, and the lack of a comprehensive legal and policy framework contributes to the many challenges that our judicial system has. During our recent oversight visits, we witnessed very serious infrastructure and maintenance problems at our courts. These include, amongst others, leaking roofs, ceilings that need to be replaced, broken air conditioning, and the courts that at times have no access to water. At the Supreme Court of Appeal, for an example, the generator is only able to light the corridors during load shedding. As the Supreme Court of Appeal courtrooms do not have windows, it is impossible for matters to be heard during load shedding, making a mockery of the right of access to justice. We note the Office of the Chief Justice assurance that the challenges raised by the judges at the Supreme Court of Appeal are being attended to. Still, we are concerned that action is being taken only after the judiciary had complained to us about the court conditions. The Office of the Chief Justice will continue with ICT-related initiatives to modernize court processes. We have repeatedly supported ICT solutions as the way forward, but the question is to whether these can have the desired effect. Unless proper attention is also given to ensuring that our courts at the very least, have got access to basics, such as running water and electricity, so that matters can run despite outages. Other things would be a house built on a faulty foundation. The committee notes the judiciary's complaint that tools of trade, such as laptops, are bought without prior consultation. We believe that there must be better communication with the judiciary to prevent misunderstandings. The committee remains extremely concerned about the increased number of backlog cases threatening to overwhelm the legal system. However, we acknowledge that the Office of the Chief Justice is unable to provide substantive answers on the backlogs, as accountability for court performance lies with the judiciary. We note that the Office of the Chief Justice is short-staffed, but funding constraints only allow it to prioritize filling posts that support core business. The Office of the Chief Justice, however, hopes that future automation of court processes will free up personnel for placement elsewhere in the organization. Space makes storing old court files a challenge. We note that the Office of the Chief Justice has made submission to the IJS for funding for the digitization of old court records, and we support this. We would like to repeat what we said in the last budget vote, and I quote, "The committee believes that the decision to implement budget cuts should be fit for purpose. In the case of the Office of the Chief Justice, it should not be forgotten that the rule of law supports healthy economies and allows people to feel safe. A functioning justice system is a glue that holds a society together," close quote. The committee, having considered the budget vote number 27, Office of the Chief Justice and Judicial Administration recommends that the House approves the budget vote. Thank you very much, House Chair.
Thank you very much, Honorable Member. The Honorable G. Breitenbach is the next speaker.
Good afternoon, Honourable Chair. Thank you very much. Honourable Chair, Honourable Members, the purpose of the Office of the Chief Justice is to render support to the Chief Justice in executing and administrative and judicial powers and the duties as head of the judiciary and the head of the Constitutional Court. The Office of the Chief Justice is therefore primarily established to support the Chief Justice and the administration of superior courts. It furthermore is required to provide and coordinate legal and administrative support to the Chief Justice and provide communication and relationship management services and intergovernmental and international coordination. It must develop a court's administration policy, norms and standards, support the development of a judicial policy, and support the judicial function of the Constitutional Court, as well as support the Judicial Service Commission in the execution of its mandate. The vote also provides for support to judicial education through the South African Judicial Education Institute, or SAJE. On recent oversight visits, it has become abundantly clear that the judiciary and the infrastructure surrounding it have been left to their own devices with very little to no support. This impacts directly on the ability of the judiciary to effectively and efficiently dispense justice throughout the country. A large contributor to this disastrous state of affairs is the complete lack of support from the Department of Public Works. The inefficiency and complete uselessness of this department is so staggering that it is clear that it should be disbanded, and the huge budget allocated to it for doing nothing at all should be distributed to individual portfolios in order that they can take responsibility for the maintenance issues that receive no or very inadequate attention from Public Works. Court buildings countrywide are in a shocking state of repair, maintenance not having been done for a decade or more, resulting in buildings once of great value now being close to derelict. The Supreme Court of Appeal has no functioning air conditioning system, no generator, and is subjected to load shedding while the residence of the Premier is not. No functioning lift, the lift shaft is filled with water and has been for some time, and the roof leaks copiously. These problems have not been addressed in the last decade. The President of the Court is forced to spend her time dealing with maintenance and infrastructure issues with little or no assistance from Public Works. It's nothing short of disgraceful. The justices have no functioning landlines, and they and the staff are forced to make use of their personal cell phones, email addresses, and data in order to get any work done. The newly opened court buildings in Limpopo and Mpumalanga are seriously below par and practically unfit for occupation. These buildings took many years more than planned to complete and overran their budgets by millions. Yet they are for all practical purposes unusable. Who paid for this? Who signed off on such inadequate, unacceptable and shoddy work, and why? The court at Palm Ridge is a relatively new court and a very busy court. It offers substandard facilities at best with serious structural deficiencies. It is time that someone is held accountable for the shocking waste of taxpayers' money on a huge scale, and the punitive clauses in the Public Finance Management Act should be implemented against those responsible for such wasteful expenditure in their personal capacities. The continually growing case backlog poses a significant threat to the judicial system. It highlights just how inefficient court processes are and underscores the dire need to modernize and digitalize the courts. Of course, this cannot be achieved overnight. In the face of these challenges, budget reductions are proposed for this office. This will contribute to an ever-growing case backlog, it will put a brake on the filling of critical posts, and seriously compromise the ability of the Office of the Chief Justice to provide the support necessary to ensure efficiently functioning judiciary. Judges have had no increases in salary for 3 years now. It is a constitutional imperative that judges' remuneration should be of a nature that guarantees tenure and independence. An impoverished judiciary is a serious risk that should not be ignored. While the ongoing training of members of the judiciary is vital in order for them to keep up with the constant developments of the digital society, the resources will not be available, again putting at risk the ability of the courts to respond adequately and quickly to matters of a complex nature. The judiciary have only limited and often sporadic access to essential tools of trade and are often forced to supply these out of their own pockets, since they are not provided for otherwise. Access to fully stocked and updated libraries remains a pipe dream, and access to electronic court reports vital to any judicial process is sparse and sporadic at best. The judiciary have very little in the way of actual support in the way of secretaries and researchers, with most having to do this themselves. And many judges are forced to type out their own judgments. This lack of access to essential tools of trade impacts significantly on finalization times and efficient adjudication of matters. As the demand increases for court time, with a long list of complex cases to be put before courts increasing daily, it is clear that the system will simply be unable to cope. A serious intervention is necessary in order to secure and rescue that which still exists, and rebuilding that which has been allowed to become obsolete. A serious and credible plan of action is needed, and it should be implemented immediately. It should definitely entail ridding us of the useless and obsolete Department of Public Works, who are unable to justify their right to exist during the oversight visits. No plans are in place to safeguard the comprehensive and very valuable books and documents housed in the Library of the Supreme Court of Appeal. The library is not fireproof, and it seems as though nothing has been learned from recent events in Parliament. The most valuable books are housed in a cabinet purchased by the justices at their own expense. The list is endless. The task is enormous. It's time that the Office of the Chief Justice was placed in a position to properly address the serious challenges currently facing the judiciary. I thank you.
Thank you very much, Honourable Member. The Honourable Yako is the next.
Thank you so much, Chairperson. Chairperson, from the moment we arrived in Parliament as the EFF, we have always emphasized on the need for Parliament to support the judiciary as a crucial component of our democracy. It is an independent judiciary, resourced with exceptional men and women who are able to interpret the law in an impartial and fearless manner that would ensure that the poor would have some semblance of protection under the law of this country. While South Africa's constitutional democracy is not perfect, our judiciary over the years jealously defended its independence. Former Justice Ismail Mohammed, as the first Chief Justice of the Constitutional Court in the country, oversaw the transition of our democracy from the parliament sovereignty preferred by the apartheid system of constitutional supremacy, in terms of which everyone will be subjected to the Constitution. Former Chief Justice Arthur Chuckelson left an imprint on the Constitutional Court and our general jurisprudence in this country that emphasized the notion of independence of the judiciary and the role of the courts post-1994 to be transformative in their interpretation of the Constitution. Former Chief Justice Pius Langa gave our judiciary a lasting legacy in his theoretical articulation of the concept of transformative constitutionalism and the need to deepen the Bill of Rights in interpreting the law. Former Chief Justice Sandile Ngcobo, regardless of the circumstances of his appointment and the controversies around the extension of his term, also maintained the independence of the judiciary and resisted attempts to capture it. Former Chief Justice Mogoeng modernized the courts and also defended jealously the independence of the judiciary. He also warned us that there were sinister attempts to capture the judiciary. We think his warning has unfortunately come true today. These leaders of the courts and many other men and women tasked with the responsibility of interpreting the law did this with integrity. They commanded the respect of their peers and of politicians and administrators because there was never any doubt that they were established judges. Today, it is difficult to maintain the same level of confidence in the judiciary, not after brazen attempts to capture it, and the seemingly biased favor of some politicians and some interests by some very top judges in the land. As recent as February, the Constitutional Court ruled that regulation relating to preferential procurement were unconstitutional, striking a deep blow on the government's weak attempts to transform state procurement. This is an affront to the legacy of transformative constitutionalism so carefully laid out by previous justices of the court. Previously, while the courts ruled to make funding of political parties public, when it was convenient to the persons now in power, they ruled that bank statements that can reveal corruption in the funding of the campaign of Mr. Ramaphosa for the ANC's presidency must be kept private, thereby protecting the corrupt interests of one individual who happens to be in power. Perhaps the biggest red flag in the degeneration of the independence of our judiciary has to be the appointment of the current Chief Justice, a man who has demonstrated his incapacity to lead the judiciary for all to see over the past few years. He sees nothing wrong with mingling with politicians and in making political commentary about things that may end up in front of him in court. He spectacularly mismanaged the Commission of Inquiry in state capture, failed to call key witnesses such as Arthur Brown, who has deep insights on the use of state intelligence for political ends. And he has asked for one extension after the other for the completion of the report that will surely be challenged in court by so many. To show that he has no intellectual backbone, for he is one, he has indicated that he saw nothing wrong with the police arresting an advocate inside a courtroom, only for him to somersault when he saw societal-wide condemnation of the conduct of the police. Excuse me. In the current Chief Justice, we have an established judge through and through, and his appointment is a reward for ensuring that the current crop of political leaders are never found to be in contravention of the law. Compared to the Chief Justice that we have had, the current one is the meekest intellectually, and the next 2 years under his tenure will be the toughest the country's constitutional dispensation. The risk of politicians capturing the judiciary is now the highest it has ever been in this country. Despite these misgivings, though, we still believe that there are men and women of integrity in our courts, and the administration of justice must continue. So as the EFF, we support the budget vote for the office of the Chief Justice while condemning the attempts at capturing the judiciary. Thank you, Chairperson.
Thank you, Honorable.
Thank you, Honorable. Okay.
Thank you, Honorable Chair. My apologies, my gadget overheated. Honorable Singh, you're the next one.
Thank you very much, Honorable Chairperson. Let me, right at the outset, on behalf of my party and its leader, Prince Mangosuthu Buthelezi, congratulate Chief Justice Zondo on his appointment as Chief Justice of South Africa. He is a judicial officer of note with many years of experience and independence in the judiciary, and we have no doubt that he will serve the judiciary well and he will serve this country well. By the same token, I think Parliament did not have an opportunity to bid farewell and thank outgoing Chief Justice Mogoeng. And I want to use this opportunity on behalf of my party to thank Chief Justice for the innovation, for his leadership, and for the changes that he made in the judiciary over his many, many years. Well done, Chief Justice Mokweng Mokweng. Honorable Chairperson, it is quite ironic that the Honorable Minister should be talking about cutbacks in the budget of this department, as we had to cut back on every other department because money had to be spent on COVID preventative measures. And, the irony is that half of that COVID money has been stolen. And it is this judiciary now that will have to prosecute and put behind bars those people that stole that money. And it is a pity that they would not have the adequate tools, financial and otherwise, to be able to carry out their duties effectively and efficiently. So right at the outset, we want to say, Honorable Chairperson, that every arm that is responsible for fighting corruption, for bringing swift justice to the people of South Africa, needs to be adequately supported by government. And this brings me to the issue that I raised before of the independence of the judiciary. The judiciary is just one arm of government, and it's an independent arm. Yet the budget falls within the realms of the executive through the minister. I think it is high time, Honorable Minister, that we do not only have administrative independence to the judiciary, but we have full independence with them handling the resources that are available to them. That is the only time we can say that we are doing what the Constitution asks of us, of having three arms of government independent from each other. It will also alleviate the whole issue of political interference that was spoken about by other speakers, and that sometimes is the perception that there is political interference in certain quarters. Honorable Chairperson, I like the fact that the Minister also spoke about the digitization and the 22 odd million rand that will be provided in the medium term for infrastructure upgrade. This is very, very necessary. And what I'd like to say, Mr. Chairman, sometimes things happen for a reason. COVID came and COVID caused us to be able to operate completely differently from the way that we did things. In fact, it brought to the fore the whole question of the use of ICT. And I think the judiciary should increasingly use ICT to conduct their cases. Many of the court rolls are clogged with civil matters, and these matters, as we saw, were handled very, very well by the judiciary through a virtual consultation. Honorable Chairperson, we are concerned about certain elements who speak of the judiciary being taken over, the judiciary being captured. Yes, there may be some within the judiciary that may have the tendency to grant favors to friends, but I do not think we must paint everybody with the same brush. By and large, we've got people of integrity sitting on our benches, and it is up to this new Chief Justice to ensure that he can maintain this level of integrity in the judiciary. According to Afrobarometer, only 42% of South Africans say they have faith and trust in the judicial system, and that the judicial system is the very edge of the precipice. It is a challenge, Honorable Chief Justice, that you have to meet head on. So finally, Honorable Chairperson, I think that, when we speak of wanting to deal with corruption, when the president stands up and says, corruption must be a thing of the past, let us give the tools to the judiciary to be able to deal with those corrupt individuals. If we do not give them adequate tools, we are failing in our responsibility. And we also believe as the IFP, even if there's a special appropriation of funds for the judiciary, for the NPA and the SIU to be able to conduct their duties efficiently, then we must make that provision. We control the budget as Parliament, and we need to make sure that we provide adequate funding. The IFP will support this budget, Honorable Chairperson. Thank you very much.
Thank you very much, Honorable Singh. FF Plus, the Honorable Mulder.
Thank you, Honorable House Chair. The South African judiciary is under threat and serious and extraordinary measures should be implemented to rectify this alarming reality. None of the articles of faith in the South African Constitution is necessarily plausible. In reality, the Constitution is not supreme and entrenched. Subjected to visible socio-economic forces, it changes continuously and often so profoundly, regardless of strict amendment requirements. Honourable Chair, I've said this in the past and I'm repeating this point of view in agreement with factual observations made by several constitutional analysts, of which the opinion of Professor Chris Malan is noteworthy, for example. The Bill of Individual Rights cannot be absolutely guarantee justice, because in South Africa, rights are often subject to the ideology-driven exercise of judicial interpretation, often with damaging consequences for those relying on the Bill of Rights. At the head of the judiciary stand the Chief Justice, of course, as guardian of our Constitution and laws adopted by elected representatives of the people. The mandate of the Office of the Chief Justice is therefore to provide effective administrative and technical support to the Chief Justice as the head of the judiciary and as head of the Constitutional Court, as well as to render administrative, operational and governance support to the judiciary. The Freedom Front Plus is therefore confident that the newly appointed Chief Justice Raymond Zondo will acquit himself with distinction, and this should therefore be supported by the Office of the Chief Justice in a more adequate manner as what realized up to now. To enable Chief Justice Zondo to implement extraordinary measures required to address our country's extraordinary circumstances, this will definitely be necessary. Honourable Chair, in saying that, and although the Office of the Chief Justice maintained a clean audit, the Freedom Front Plus is concerned about the medium and long-term consequences of the government attempt to slow expenditure growth by reducing baseline budgets and setting ceilings on compensation spending, which resulted in a wide gap between revenue and expenditure, increased pressure on basic delivery of a lack of progress. Developments such as the laying of security services at the courts to the Office of the Chief Justice, inadequacies in ITC security and user access management, as well as ICT operational inefficiencies are just a few examples of concern. Courts also experience serious infrastructure and maintenance problems. Last year, South African courts are not capacitated to effectively deliver court services in line with standards and court rules, and this should be rectified without delay. To be able to rectify this unfortunate and serious situation, the South African Constitution should firstly be respected, and the Office of the Chief Justice should be equipped to support a respected Chief Justice to fulfill his mandate. The Freedom Front Plus does not support this report. Thank you, Chair.
Thank you, Honourable Mulder. From the ACDP, Honourable Salto has indicated that it would be someone else.
No, thank you, House Chair. I am online. Should I be not heard, then
welcome, Mr. Salto.
Thank you so much. Well, thank you, House Chair. The ACDP would firstly like to congratulate the new Chief Justice, Mr. Justice Raymond Zondo, on his appointment. We'd also like to thank former Chief Justice Mogoeng on his service to the nation. And we'd also like to pay tribute at this stage to the judiciary for holding the line against state capture and corruption, as now fully laid bare by the Zondo Commission. The courts have indicated and acted with fearlessness and indicated an independent judiciary, which we as the ACDP salute. We commend the Office of the Chief Justice on maintaining a clean audit and thank all its staff for their hard work. However, the ACDP shares deep concerns expressed by the committee at the state of many of its courts following its recent oversight visits. During those visits, the committee witnessed firsthand very serious infrastructure and maintenance problems. Many of the courts are old. The failure to maintain them quickly then becomes a costly renovation project where leaking roofs remain unfixed, ceilings that must be replaced, broken air conditioning, etc., etc. For example, at the Supreme Court of Appeal, the generator is only able to light the corridors during load shedding, and then it's obviously impossible for cases to continue. This makes a mockery of access to justice. The question arises, why does the SCA itself even have load shedding? Whilst the criticism of the OCJ may be unfair, it has a challenging role of liaison between the judiciary and the public works and justice departments, but more clearly can and should be done, and much of the blame must be laid at the door of public works. We note the OCJ's assurances that the challenges raised at the SCA are being attended to, but are concerned that it seems that action is only taking place after the judiciary raised its complaints with the committee. This should not be the case. We also share the concern about the lack of finalizing of the court administration model, and would like to see advances in this regard. Lastly, in response to an ACDP question relating to what involvement the judiciary has in its own budget, the CFO of the OCJ indicated that heads of court were consulted. However, beyond that, the judiciary and the OCJ is treated as just another department. Now, this can't be correct, given the crucial role the judiciary plays as a third arm of state in ensuring justice in the country. The former Chief Justice Mogoeng raised his concerns in this regard, and the ACDP agrees. The OCJ and judiciary need to be able to play a far greater role in the determination of their budget to ensure effective access to justice is ensured. The ACDP will support this budget vote. I thank you, House Chair.
Thank you very much, Honorable Swartz. Honorable the Deputy Minister of Justice and Correctional Services, responsible for justice and constitutional development. It's your turn, sir.
Honorable Chairperson, Honorable Minister Ronald Lamola, Deputy Minister Patekile Holomisa, Ministers and Deputy Ministers, Honorable Members, members of the Judiciary who may be watching, and officials of the Office of the Chief Justice. The Office of the Chief Justice was established in 2010 as a new government department separate from the Department of Justice and Constitutional Development to, amongst others, support the Chief Justice in executing their administrative and judicial powers and functions as head of the judiciary. It supports the Judicial Services Commission and the South African Education Institute in the execution of their mandates, and administers the Judges' Remuneration and Conditions of Employment Act. The OCJ is responsible for running the Superior Courts, the High Courts, the Supreme Court of Appeal, and the Constitutional Court, as well as specialized courts such as Labour Courts and the Competition Appeal Court. The establishment of the OCJ was the first step in ensuring greater independence to the judiciary. In today's debate, though, I'll be speaking about the magistrates, because although the magistrates' courts are still administered by the Department of Justice and Constitutional Development, magistrates are part of the judiciary. Section 165(6) of the Constitution, read with Section 8 of the Superior Courts Act, provides that the Chief Justice is responsible for the establishment and monitoring of norms and standards for the exercise of judicial functions of all courts, and thus enjoins the Chief Justice to issue protocols or directions to all judicial officers, that is, both judges and magistrates. The coordination of judicial functions of magistrates' courts falling within the jurisdiction of the division of the High Court is the responsibility of the Judge President of that division. Many of you may recall that in the past, magistrates were public servants appointed from within the Department of Justice, and thus part and parcel of the public service. Today, our magistracy is independent. For example, a magistrate cannot be suspended or fired by the Minister of Justice. This process now involves an investigation and a hearing by the Magistrates Commission, as well as the concurrence of Parliament. The new Magistrates Bill and new Lower Courts Bill, which were referred to by the Chair earlier, have been long outstanding, but we are pleased that the introduction of these bills is expected to take place this year. The purpose of the Magistrates Bill is to provide for the establishment, constitution, objects and functions of the Magistrates Commission, and will regulate the appointment, conditions of service, remuneration, retirement, suspension, and removal of magistrates. The main aims of the bill are threefold. Firstly, to replace the current Magistrates Act of 1993 in order to ensure the autonomy of the lower courts judiciary from the executive. Secondly, it aims to incorporate all the provisions relating to the appointment of judicial officers of the lower courts in the bill itself, since some of these provisions are presently contained in the Magistrates Court Act of 1944. Thirdly, it aims to bring the procedure for dealing with complaints about magistrates' conduct in line as far as is possible and feasible with the dispensation applicable to judges in the superior courts. The bill was published for public comment on the 25th of March with a due date for comment by the 29th of April last month, but we've now extended the due date to the 15th of June. The new lower courts bill aims to provide for the establishment, composition and functioning of lower courts comprising of regional courts, district and municipal courts, and to make provision for the administration of the judicial functions of the lower courts. At the heart of this bill is the fact that before the advent of the democratic dispensation in 1994, magistrates' courts were not constitutionally recognized as part of the judicial authority. The new lower courts bill highlights the fact that the legislative framework relating to the superior courts has been rationalized and consolidated through the Superior Court Act of 2013, which, as I have said, provides that the judge president of a division of the High Court is also responsible for the coordination of judicial functions of all magistrates' courts falling within the jurisdiction of that division, and that since the Constitution provides that the judicial authority is vested in all courts, it's desirable to provide for a uniform framework for judicial management by the judiciary of all the judicial functions of all courts. The due date for comments on the lower court bill is also the 15th of June 2022. We will be engaging with magistrates organizations on the bill, such as Johnson and Adams, but I also want to urge all interested parties and stakeholders to provide comments on these important bills. These bills, once passed, will indeed be the culmination of a significant milestone in the administration of justice. But honourable members, whilst we make very real progress with the legislative framework, we must also acknowledge that our magistrates' courts and the users of these courts face many challenges, such as infrastructural challenges, lengthy court processes, case backlogs, and faulty court equipment. The only way to overcome these challenges is to look at who is responsible for what in our courts. There are judicial functions and there are administrative functions. The Constitution contains very specific roles for both the Chief Justice and the Minister of Justice, or as they are described in the Constitution, member of Cabinet responsible for the administration of justice. The Chief Justice is the head of the judiciary and exercises responsibility over the judicial functions of all courts. The Cabinet member responsible for the administration of justice appoints acting judges to other courts after consulting the senior judge of the court on which acting judge will serve, and exercises final responsibility over the prosecuting authority. The Superior Courts Act also sets out judicial functions in Section 8, Sub 6, to be performed by the judiciary, as well as sets out the responsibilities of the minister responsible for the administration of justice. The issue of case backlogs is one that comes up time and time again. There sometimes in some areas appears to be a perception that whenever there are backlogs in courts, it's the fault of the department and thus the responsibility of the executive to fix. But such a point of view does not take cognizance of the important fact that court efficiency lies within the purview of the judiciary. I do note that the committee report that we're debating today did acknowledge that the OCJ was unable to provide an input on the backlogs, as court performance lies with the Chief Justice and the heads of court. There are, however, a number of stakeholders within our court system, and for the system to work optimally, they must all play their part and work together to reduce backlogs. The Chief Justice has set norms and standards for the exercise of all judicial functions in the courts. In terms of the norms and standards, civil cases in the magistrates' court should be finalized within 9 months from the date of summons. In criminal matters, judicial officers should strive to finalize criminal matters within 6 months after the accused has pleaded. The Honourable Horn, speaking later, recently tabled a parliamentary question to the Minister of Justice as to how often the National Efficiency Enhancement Committee and its provincial equivalents have been meeting. These are convened by the Chief Justice and the Judges President. But the OCJ, when the question was referred to them, made it abundantly clear that these are judicial governance stakeholder forums which are chaired by the Chief Justice and the judges presidents of the High Courts respectively, and therefore the Honourable Horn's question was to be referred to the Chief Justice for consideration and not to the Minister of Justice. The National Efficiency Enhancement Committee and the provincial equivalents and district equivalents play a crucial role in court optimization where all relevant role players meet. Often many challenges exist in courts because these structures don't meet regularly enough. The OCJ has set targets and indicators in their annual performance plan which point to improved court efficiency, and specific and measurable output indicators such as the percentage of default judgments to be finalized by registrars within 14 days from the date of receipt of the application, the percentage of taxation of legal bills of costs to be finalized within 60 days from the date of set down, the percentage of warrants of release to be delivered within 1 day of the release issued, and the number of judicial case flow management performance reports to be produced. In an attempt to ensure cooperation and better synergy in court performance and to support our magistrates' courts, we established a court optimization committee in 2020 to bring together stakeholders and the magistrates' judiciary in order to address challenges and bottlenecks in our courts. The Court Optimization Committee consisted of the Court Services and Corporate Services branches of the Department of Justice and Constitutional Development, the Regional Court Presidents Forum, the Chief Magistrates Forum, the South African Police Service, the National Prosecuting Authority, Legal Aid South Africa, the Department of Social Development, the Department of Health, the Department of Correctional Services, and the 9 regional offices of the Department of Justice and Constitutional Development. The Court Optimization Committee worked well until the regional court presidents decided to withdraw from the structure, despite our best efforts to convince them to remain. We, though, will continue to do whatever we can to strengthen and support our magistrates' courts and our magistrates. We need to ensure that the department moves more expeditiously in providing the magistracy with the necessary tools of trade and the necessary equipment so that our courts can function optimally. We are constitutionally bound to improve our efficiency in this regard. The creation of inclusive and integrated magisterial districts and sub-districts in respect of the outstanding provinces of the Eastern Cape, Free State, KwaZulu-Natal, and the Western Cape through the rationalization of the magisterial districts project has been finalized and was gazetted by the Minister and came into effect on the 1st of April 2022. Of paramount importance going forward is the rationalization of the judicial establishment of the lower courts, as it will impact not only on vacant posts in which persons are appointed to act, but also on permanent posts of magistrates that will become vacant in the near future. Chairperson, honourable members, as I stated earlier, for our courts to function optimally and for cases to be disposed of speedily, we also rely on a number of other stakeholders and role players, such as the Department of Public Works and Infrastructure, which has been subject to quite a bit of criticism, the South African Police Service, the Department of Correctional Services, Legal Aid South Africa, and the legal profession. We shall continue our efforts to ensure proper and improved coordination between ourselves and these stakeholders. We will also continue to support the Magistrates Commission in its work. I feel I need to respond to Honourable Yakor's comments on the judiciary and in particular the Chief Justice. Chairperson, I think this is something that the House should investigate because we are meant to be protecting the independence of the judiciary. And I want to urge members and members of the public not to unnecessarily attack the judiciary without a basis, without substance, without facts. But just raising rumors doesn't help, and it doesn't ensure the legitimacy of those structures. We will continue to support and strengthen our courts and our judiciary. In the words of the late Chief Justice Ismail Mohammed, and I quote, "The Constitution articulates a culture of rights and freedoms, especially meaningful for a people deeply traumatized and agonized for so long by the denial of such rights. but the articulation of such rights would afford no protection against abuse in the absence of constitutional agencies with the power to police abuse and to protect the victims of abuse. The judiciary is the cornerstone of that protection. Its constitutional power is formidable. Thank you.
Thank you, Honourable Minister, and thank you, Tate Ntombela. Now, honourable members, we shall proceed and recognize member of the UTM. Honourable members, we shall proceed and recognize Honourable Heron from Good.
Thank you, House Chair. House Chair, where justice is denied, where poverty is enforced, where ignorance prevails, and where any one class is made to feel that society is an organized conspiracy to oppress, rob, and degrade them, neither persons nor property will be safe. Those were the words expressed by the escaped slave and public intellectual Frederick Douglass nearly 200 years ago, and they are as applicable to the US then as they are to South Africa today. Justice does not exist in books or statutes alone. It is not a theoretical concept, nor should it be mysterious, nor honed in Stalingrad. For people to believe in the fairness of a state, in its integrity, in equal rights, justice must be seen to be done. For justice to be seen to be done is dependent not on judges alone, but also arguably more so on the integrity of the criminal justice system as a whole, including its investigative and prosecutorial arms. Judgments can be appealed, which is a public process, but for good reasons, the decisions made by the police and prosecutors before cases reach court or don't are often made behind closed doors. The integrity of the judiciary is therefore linked to the integrity of the processes that underpin it. We cannot talk of justice being done in South Africa if the NPA receives instructions not to prosecute apartheid war criminals, for example. We can't talk about justice being seen to be done when detailed knowledge of state capture has been in the public domain for more than 5 years, but virtually none of the perpetrators have been charged or brought to court. And we cannot talk of justice when those cases that are enrolled are beset by delays, postponements, lack of coordination between prosecutors and police, and sometimes incompetence. That is not justice. It is what some people call lawfare. We have a constitutional order that is globally admired, but also a combination of red tape, political interference, and systemic indecisiveness that plagues our system of justice. The quicksand that we are in is epitomized by the legal battles of former President Zuma. Despite years of allegations, investigations, and attempted prosecutions, the ability of skilled lawyers to manipulate the system is self-evident. Being innocent until proven guilty is a foundation stone of justice, but the foundations become shaky when alleged criminals have the means to delay the implementation of justice and therefore retain their innocence, despite the existence of piles of evidence in the public domain. As we fiddle around the edges, the culture of criminal impunity in the country gathers momentum to all of our detriment. Among the greatest weapons we have to fix this is an Office of the Chief Justice being seen to be playing a leading role in the administration of justice, independent of any interference. To be seen to be playing this role, it is dependent on vigorous, competent, and independent investigators and prosecutors. Chairperson, we support the budget. Thank you.
Thank you very much, Honourable Member. Now we shall proceed. I recognize member from Cope. Now I recognize PAC. Any member from PAC? We shall proceed. Now I recognize member from Honourable Member Sheikh Imam. Honourable Sheikh Imam. We shall proceed, honourable members, to Honourable Horn. Honourable Horn of the DA. Understand that you have been advised about 1 minute extra that you have. Honourable Horn.
Okay, thank you. This year, as the Honourable Minister pointed out, Chair, we are celebrating the 25th year since our Constitution came into operation. A Constitution which as our supreme law in a deliberate and foundational manner, determined not only that we are to be served by an independent judiciary, but which has also entrusted our judiciary with the responsibility to act as a final arbiter, not only when we have disputes with one another, but also when we dispute the legality of law or lawfulness of any action by those who exercise any public power.
Honorable Velma, while just fix your connectivity. Honorable Horn, can you hear me?
I can hear you, House Chair.
Okay, I'm requesting that probably for you to have a better connectivity. Just hold on. Let me allow Honorable Velma from the ANC, then you come in. Just get a better place, please. Thank you. Honorable Velma, over to you, ma'am. Honorable Velma.
Thank you, Chairperson.
Okay, thank you.
Honorable Chairperson, greetings to ministers, deputy ministers, to all honorable members on this platform, to all those in safety and security cluster, and all those who are watching from home and all the media present. Chairperson, before I start my speech, I'd like us all to remember all those who lost loved ones in the COVID-19 pandemic during the July unrest, and as well as in the terrible flooding that happened in KwaZulu-Natal and Eastern Cape, and those who were affected by the fires in the Western Cape. My condolences to their families. I also offer my condolences to the Gardee family and to families who have lost loved ones through gender-based violence and femicide. I would also like to add my congratulations to the new Chief Justice Zondo for his appointment, and also farewell to the outgoing Chief Justice Mogoeng. The Portfolio Committee on Justice and Correctional Services received a presentation of the 2022-2023 Annual Performance Plan from the Office of the Chief Justice. The committee appreciates the fact that all entities are operating in difficult financial times, made worse by this pandemic in various ways. On the 23rd of August 2010, the President of South Africa proclaimed the Office of the Chief Justice as a national department within the public service by means of Proclamation 44 of 2010. The establishment of the OCJ was envisaged as the first phase towards an independent judiciary-led court administration system in order to fully realize the judiciary's institutional independence in line with the Constitution. The purpose of the Office of the Chief Justice is to provide support to the Chief Justice in executing administrative and judicial powers and duties as the head of the judiciary and head of the Constitutional Court. Chapter 14 of the National Development Plan explains the important role that the judiciary has to play to strengthen judicial governance and the rule of law. The OCJ has a duty to support the judiciary in the realization of this vision. The OCJ functions under the principles that the full realization of the country's vision as articulated in the NDP will culminate into a country that is accountable and progressive in its political, economic, and social standing. In implementing its mandate, the OCJ provides support to promoting accountability and fighting corruption. The contribution to the NDP priority is done through accelerating reform to implement a judiciary-led court administration, ensuring an efficient court system, reducing court administration inefficiencies, and ensuring access to justice. The OCJ also contributes to Chapter 13 of the NDP, which is building a capable state by ensuring good governance in the administration of the department. The fight against and elimination of fraud and corruption in the public service remains one of our government's priorities. The late former President Tata Mandela once warned us about corruption, saying, and I quote, "Our hope for the future depends also on our resolution as a nation in dealing with the scourge of corruption. Success will require an acceptance that, in many respects, we are a sick society." Close quote. The OCJ has over the years put in place strong measures to prevent fraud and corruption, and this work will be intensified during the 2022-23 financial year. The Minister mentioned to the committee in his political overview on the 3rd of May 2022 that special commercial crimes courts have been established in every province. This will enable the courts to cope with the work. As the Minister mentioned, there has been a rise in serious commercial crimes and incidents of the COVID-19 corruption, and also the findings arising out of the Zondo Commission, which was set up by our president. This meant that the establishment of additional commercial crimes courts had to be fast-tracked and to be able to increase the capacity of the existing courts. To date, special crimes courts have been established in the provinces where such courts did not exist before, like Limpopo, Mpumalanga, Northern Cape, and the Northwest Province. During the Honorable President Ramaphosa's appearance at the Zondo Commission, he said, and I quote, "The ANC had called for the commission. The ANC, in their 54th conference, had supported a judicial commission of inquiry, and the ANC maintains that the commission was a necessary part of the broader social effort to end all forms of state capture and corruption." Unquote. Fighting crime and corruption and ensuring that all people feel safe is the battle cry of thousands of women and children. Statistics South Africa shows that there are about 30 million females living in the country. According to the OCJ, this growth in the population has a socio-economic impact which has the potential to overburden the already overstretched judicial system. However, South Africa aims to build a safer community by 2030 to ensure that people living in the country feel safe and have no fear of crime. This extends the protection to women, children, and the vulnerable individuals in society. The NDP envisages that communities should have confidence in the criminal justice system to effectively apprehend and prosecute criminals who violate community safety. The 2019 South African Sustainable Development Goals country report recognizes that there is still a lot of work that needs to be done in relation to the elimination of violence against women. The Portfolio Committee have passed the 3 GBV bills, which were signed by the President of the country. These 3 bills, the Criminal Matters Amendment Act, the Domestic Violence Amendment Act, and the Criminal Law, Sexual Offences and Related Matters Amendment Act, has been strengthened to go a long way to assist women and children against the violence done to them. The Minister also informed the committee that the state of our justice services will be assessed to improve the level of integration in the justice system and assess gender-based violence infrastructure with a specific focus on the new acts and the National Strategic Plan on gender-based violence and femicide. And I repeat, fighting crime and corruption and ensuring that all people feel safe should be our battle cry. The ANC supports this vote. Number 27. I thank you, Chairperson.
Thank you, Honourable Member. Now we shall proceed. As indicated earlier on, we'll go to Honourable Horn of the DA.
Thank you, Chair. Let me try again. This year, we are indeed celebrating the 25th year since our Constitution came into operation. A Constitution which is our supreme law in a deliberate and foundational manner determined not only that we are to be served by an independent judiciary, but which has also entrusted our judiciary with the responsibility to act as the final arbiter, not only when we have disputes with one another, but also when we dispute the legality or lawfulness of any action by those who exercise any public power. One of the fundamental human rights we enjoy in terms of this Constitution is freedom of speech. It is this exercise of this freedom which enables even those who believe that the rule of law must be replaced with the rule of man by substituting the supremacy of our Constitution with the supremacy of this legislature, the National Parliament, to air this myopic view in public. From our side, Chair, we are unequivocal in our support for and our resolve to protect the supremacy of our Constitution, the rule of law, and the independence of our judiciary. The best protection against these attacks on the rule of law is, of course, to ensure strong trust and confidence amongst ordinary South Africans in the judiciary as an independent and effective arm of state. On this score, the announcement by the Minister during his political briefing of the Portfolio Committee on the 3rd of May that this government is finally ready to proceed to establish a judicially-led court administration model is appreciated. We would have welcomed and appreciated if he included this in his budget speech today, and we call on the Minister to finalize this, as this is long overdue, and the almost decade-long standoff between the judiciary and the executive on this issue served no other purpose than to undermine the independence of the judiciary and our constitutional democracy. Chair, quite possibly the one thing we have, however, learned from this protracted standoff is that this model will have to ensure that a proper system is put in place to ensure not only the operational independence of the judiciary, but in a correlating manner, a system which will also ensure that the judiciary properly accounts for its use of public funds. On this score, the judiciary must take upon itself a leading role in making the case backlog go away. Chairperson, accounting must also happen to this legislature, being the authority entrusted by our Constitution with the appropriation of public funds and being the authority entrusted with oversight in respect of the spending of public funds. Similarly, this system will, for the sake of the judiciary, but more importantly for the sake of our constitutional dispensation, have to ensure that the judiciary properly deals with all matters within its authority that holds the potential to undermine and erode its own independence. And this would in simple terms mean that the judiciary must deal with allegations of impropriety and misconduct in its own ranks in a speedy, effective and transparent manner. The judiciary must understand that its failure to do so invariably will hold the dangerous potential that public trust and confidence in it will be undermined and eroded. Chair, while adding our voices to those who have used this debate to congratulate Judge Zondo on his appointment as our Chief Justice, we do so knowing that our new Chief Justice will need no reminder that with great power comes great responsibility. Another issue which will require the wisdom of Solomon from our new Chief Justice, but in respect of which it's equally important that he gives decisive and effective leadership in order to prevent a situation where the trust and confidence of South Africans in the judiciary will be undermined, is the manner in which the Judicial Service Commission under his leadership will deal with interviews of potential judges. Unfortunately, there's a growing perception that the JSC is becoming merely a stage for political deals, manipulation and score setting, to the point where good appointments to the bench happen despite the JSC and sadly not because of it. In addition, the time has indeed come to call on the JSC to also work towards a course correction in respect of the way in which it exercises its constitutional duty to consider the need for the judiciary to broadly reflect the racial and gender composition of South Africa when recommending candidates for appointment to the bench. The guidelines for questioning of candidates for nomination to the first constitutional court adopted in 1994, right at the dawn of our democracy, in very clear terms stated that if our constitution makers clearly did not opt for a court which should represent the races and genders in direct proportion to their share of the national population, it must follow that the JSC cannot act as if this was indeed the case. Chair, now is the time for the JSC in embracing the foundational principles of our constitution, which includes non-racialism and non-sexism, to be guided again by this and another portion of the 1994 guidelines, which are in conclusion quotes, and which in an instructive manner directs as follows. The constitution maker is not concerned with the interests of the individuals who, by appointment to the court, might benefit from its instruction. Its concern is with the effectiveness of the court as an instrument of justice. I repeat, its concern is with the effectiveness of the court as an instrument of justice. I thank you.
Thank you, Honourable Member. Honourable Members, we shall proceed to Honourable Lamola, and I'm sure, Honourable Lamola, we have been advised that you've got additional 5 minutes. That will give you 18 minutes. And as well as Honourable Minister, you've got additional from your 5 minutes that you left earlier on, and also from DM, which makes it additional 7 minutes. Over to you, Honourable Lamola. Oh, Honourable Lamola.
Can you hear me, Chair?
Yes, I can now. Thank you very much.
Chair, I was saying, please allow me to have my video off. I'm terrible.
Okay, you are permitted. Permission granted.
Thank you, Chair. Chairperson, on the occasion of the debate on Budget Vote 27, I wish to express my deepest condolences to the families who lost their loved ones in the devastating floods in KwaZulu-Natal. Many families lost their homes, belongings, and so much more. The natural disaster could not have come at a worse time. The country and the world at large are still grappling with the negative effects of the COVID-19. But even as we face these difficulties as a people, it is perhaps important to remind ourselves of what former President General Oliver Tambo Mbeki said, and I quote, "Gloom and despondency have never defeated adversity. Trying times need courage and resilience. Our strength as a people is not tested during the best of times." Chairperson, in keeping with celebrations of the 25th anniversary of the Constitution, it is perhaps necessary to reflect on its genesis. Constitutional Principle 4 of the Constitutional Principles negotiated at the multi-party negotiating process in the early 90s and annexed to the interim constitution provided that there shall be a separation of powers between the legislature, the executive, and judiciary, with appropriate checks and balance to ensure accountability, responsiveness, and openness. When certifying the 1996 Constitution, the Constitutional Court had to consider whether the new Constitution did indeed comply with this principle. In responding to the challenges raised to the text of the Constitution, the Court reasoned that there is, however, no universal model of separation of powers, and in democratic systems of government in which checks and balances result in the imposition of restraints by one branch of government upon another, there is no separation that is absolute. The doctrine of separation of powers, on the one hand, recognizes the functional independence of branches of government. On the other hand, the principle of checks and balances focuses on the desirability of ensuring that the constitutional order as a totality prevents the branches of government from usurping power from one another. In this sense, it anticipates the necessary or the unavoidable intrusion of one branch on the terrain of another. No constitutional scheme can reflect a complete separation of powers. The scheme is always one of partial separation. The drafters of the first democratic South African Constitution regarded the separation of powers not as a goal in itself, but a means to democracy and a good governance. To prevent a government preoccupied with its own self-interest, detached from the people and inclined to non-transparent backroom politics. The Constitution would have to distribute political power between the different branches of government. Bodies like the Magistrates Commission and the Judicial Services Commission play an important role in administration of justice and protecting judicial independence. Separation of powers, an independent judiciary, and respect for the rule of law are some of the democratic gains which must be defended. An independent judiciary is a fundamental element of democracy. As the ANC, we reiterate our support for it. Chairperson, another democratic gain is our constitutional democracy, which is based on the will of the people. We shall all remember the Freedom Charter that is instructed South African society that the will of the people govern. The practicality of this provision was that the legislature, which did not represent the will of the majority of the people, could enact whatever legislation it desired. The result of which was the enactment of repressive laws and denial of human rights. Unlike in the present day constitutional democracy, courts during apartheid did not have the power of judicial review by which they could determine the legality of acts of parliament. Instead, courts were confined to interpreting legislation. Our constitution is internationally acclaimed as progressive. It guarantees first, second, and third generation rights. Our courts are empowered to interpret and enforce the Constitution. Rich jurisprudence giving effect to the Bill of Rights has been developed by our courts. The mandate of the Office of the Chief Justice is to provide effective administrative and technical support to the Chief Justice as the head of the Judiciary and the Constitutional Court. The Office of the Chief Justice was established as a measure to promote and reaffirm the principle of judicial independence, as guaranteed by Section 165 of the Constitution. The OCJ's core function is that of providing administrative support to the judiciary and has adopted the following strategic outcomes: effective and efficient administrative support, improve court efficiency, enhanced judicial education and support. In this way, the OCJ responds to Chapter 14 of the National Development Plan, promoting accountability and fighting corruption, particularly contributing to the focal area strength, judicial governance, and the rule of law by accelerating reforms to implement a judiciary-led court administration, ensuring an efficient court system, reducing inefficiencies in the administration of courts, and ensuring access to justice. Honorable Chair, last year during the debate on this budget vote, we acknowledged that COVID-19 and the national lockdown had a negative bearing on the operations of courts. We are concerned about the workload in our courts, which has increased the backlog of cases. We reiterate that we do not wish to see the legal system overwhelmed and the right to access to justice undermined. Justice delayed is justice denied. It is vital to ensure that the courts have sufficient capacity in order to efficiently deliver court services in line with the standards and the court rules. It has been reported that during the 2022-2023 financial year, the OCJ will continue with digitization of the court system, with a focus on prioritization of court online and the digitization of court records, as well as the e-judiciary system. It has also been reported that to strengthen access to its services, the department plans to employ 5 researchers and 19 registrars over the period. This additional capacity will enable it to increase the percentage of default judgments finalized within 14 days and ensure that all warrants of release are delivered within 1 day of being issued. Funding for these initiatives is with the Superior Court Services Program's allocation of 2.8 billion over the medium-term expenditure framework period. Lastly, we wish our newly appointed Chief Justice Zondo everything of the best in his new role. The African National Congress supports this budget vote. Thank you very much.
Thank you, Honourable Member. Honourable Members, before we recognize the Honourable Minister, I just want to draw to your attention in terms of Rule 88, reflections upon judges and certain other holders of the public office. No member may reflect upon the competence or integrity of the judge of a superior court, the holder of a public office in a state institution supporting constitutional democracy referred to in Section 194 of the Constitution, or any other holder of an office other than a member of government, whose removal from such office is dependent upon a decision of the House, except upon a separate substantive motion in the House presenting clearly formulated and properly substantiated charges, which, if true, would, in the opinion of the Speaker, prima facie warrant such a decision. I thought that I must bring to attention to in terms of that Rule 88. I understand that the Minister Deputy Minister felt upon himself to deal with that matter. We were still going to make a decision upon that, Honourable Members. So we must be mindful of the rules and how we engage in our debates. Honourable Members, allow me now to recognize the Minister of Correctional Service, Justice and Correctional Services. Over to you, Honourable Minister.
Yeah, thank you, Honourable House Chairperson, and I welcome the rule and the ruling that we have just given now, it will protect our constitutional democracy from the howlers and the people who just bring unsubstantiated allegations against the members of the judiciary. It's a very important rule, which I hope will be used to continuously remind the members, and some of these unsubstantiated allegations will be struck off the record of this House. The infrastructure issues raised, Honorable House Chair, indeed, it is a point of concern, even for the executive. Hence, we have meetings with the Department of Public Works and Infrastructure to look at the issues of devolving some of the powers which are vesting within that department, to help the department to have also OCJ to have some of these delegated responsibilities to be handled by them on some of the ad hoc maintenance issues that the departments could be able to handle. And this will also have to be followed, not only with the powers that are devolving, but also with a budget that will also enable these two departments of skills in the infrastructure space, like engineers, and the relevant skills like artisans, even to just have a handyman, Honorable House Chairperson, who can just be employed if you have to change a loop. I mean, sometimes you don't really need a tender to change loop. So we are all looking at some of those to just have some of these basic maintenance, to change a broken window and all that, but also to in some of the ad hoc maintenance that the departments can be able to handle. So indeed, this is a matter of priority, and we are indeed in discussion with the Public Works, and we are hopeful that we will be able to conclude the discussion soon. And as I've said when I was briefing the committee, one of the sticking points that we are still finding a solution on is the issue that the devolution of these powers should go with the budget. Because if it does not go with the budget, the devolution of the power will be meaningless, because the departments may not be able to execute the mandate. And that goes with this discussion, and hopefully we will soon find a solution, because indeed the court infrastructure across the country is facing severe challenges that needs immediate attention from all of us. And we want to thank the Portfolio Committee for their work of oversight across the country, which has exposed and has also made them aware of some of the challenges that the courts are facing. And I do believe with what the Portfolio Committee has pointed to us, which we have also sent to the Department of Public Works, we will be able to find a solution soon. And I also want to state categorically on the issue that with regards to the current Chief Justice, the current process of appointment of the Chief Justice, that for the first time in the history of our democracy, the President of the Republic of South Africa shared his powers to participate and even recommend who could be the Chief Justice. It was the most transparent, the most open process, which involved everyone. And the Chief Justice who has been appointed is an outcome of the most involved forms of participation the country can ever have. It is very unfortunate that even with the president sharing his powers with everyone, there is still people who find ways to accuse him of judicial capture attempts. If he wanted to capture the judiciary, or if he had any mind of doing so, if he had such an ambition, he will not have shared this power. He will not have been transparent in the appointment of the Chief Justice. But to show that the president has got no ulterior motive other than the interest of the country as espoused in the Constitution, he said, despite the fact that he has got a power which he could have exercised, used, and still be within the ambits of the Constitution and still be protected, he said, let me allow the people of this country, give them an opportunity to play a role. And this is something that should be commendable, and the president should be appreciated for sharing this power and responsibility with the people of this country. And for that reason, there cannot be any basis by anyone, including the EFF for that matter, to want to argue and come with unfounded attempts of a judicial capture. And Chairperson, I also want to state categorically that the courts have ruled with regards to the bank statements, that the issues that have been raised here. There are checks and balances in our court system. The court has made a ruling on the matter, and the matter is within the confines of the Constitution. It is within the parameters of our laws as a country. You cannot have untrammeled and unlimited private access to personal information of anyone in the country. Hence, we even have the information regulator. We have various bodies aimed to protect the information and also to protect the individuals in this country. So that is also another unfounded statement that has been made by Honorable Yako. I hope that she will go and read the judgment to get the tenets of our democracy and of our constitution, the architecture that protects everyone, including herself. And there is no Arthur Brown, Honorable Chairperson, that was denied to present information of national intelligence nature. Maybe she made an error. She may need to go and research, because Arthur Brown is a person that we had in our correctional facilities. It's a person that honorable members will remember with regard to the Fidentia scandal. So I think maybe she needs further research, and in future she needs to check properly her facts and also check the names of people that she wants to talk about, because it's very dangerous to just talk about names of people without checking properly. You will end up having lots of problems of clarifying and not being able to substantiate your views because of mentioning names without verifying. It is the hallmark of lack of diligence in your parliamentary work. With regard to this issue of the budget cuts, I agree, Chairperson, that indeed it is an issue of concern even for us as a department. It's a big concern that we have, and while we do say that we have to do with the limited resources that we have, we still continue to understand that this is a big challenge, and we will continue to find ways of living within what we currently have and trying to resolve these budgetary challenges as we move forward. And I agree with the Honorable Singh on the Afro barometer that speaks about the confidence of the people of this country on the judiciary. In fact, that is the proper reference point in terms of the confidence to the judiciary, because it's a scientific method that has been used to assess the trust of the people. Any other insinuations are out of a political expediency, and this political speak is not informed by any scientific assessment that has been done. So the Afro barometer indeed is something that for us to restore the trust and the credibility beyond the 40% that the Afro barometer has said, we must desist from making unsubstantiated allegations. We must allow the judiciary to do their job without any fear, favor, or prejudice, allow them to exercise the powers entrusted to them by the Constitution. And I also agree on the issues of efficiency in terms of the digital platforms that the Office of the Chief Justice can use to enable them to achieve efficiency. And with regards to the report on state capture, from the comments that has been raised, the commission of inquiry was appointed by the former president. They wanted to ensure that we go into the bottom of the matter, and we now have some of the reports of the commission, installments of the reports, and the intention is to ensure that they are implemented to the latter. And as members are aware, it may not be an overnight thing, but it's something that needs to be carefully considered by everyone, including the law enforcement agencies, and ensure that the implementation is above reproach. It can be able to withstand any scrutiny in a court of law or in any platform. So I do think we need to allow them and give them a chance to implement these recommendations and reports of the State Capture Commission. Honorable Horn will be pleased to hear that all the documents he has referred to from 1994 in terms of the work of the Judicial Service Commission were reference point in the last meeting of the Judicial Service Commission, and the commission has went through a workshop before the sitting, and we have gone through all those documents, including the protocols that have been established over time by even various international bodies and the work. So, Honorable Horn, those documents have been put into good use in the last sitting of the Judicial Service Commission, and the commission intends to continue to put them into good use. And I agree with the Honorable Lamola on the fact that the tenets of our constitutional democracy should continue to be respected and should continue to help us to be a functioning nation. We have been able to function for the past 25 years in our constitutional democracy, and the lessons that we've learned in that 25 years, we need to use them to propel ourselves to go forward, including some of the groundbreaking judgment on socio-economic rights by our courts, because we are now in a phase where we need to deal with challenges of inequality. The transformative agenda has to be entrenched through the interpretation and the socio-economic rights by our courts, and it is in that regard that we have to continue to ensure, even within the executive, the various laws that are aimed to empower the people of this country, the BE laws, which we have to look into again in terms of the preferential procurement framework that are aimed to put the set asides for particular vulnerable groups. Cabinet is looking into all those issues to ensure that we continue to bring this empowerment to the people of our country. So we have no intention of abandoning, but we've got an intention of complying and doing it in line with the judgment. And the transformatory agenda in terms of bringing equality, economic empowerment, is what must now take us into the next phase of our democracy, beyond the 25 years where we had laid all the rights. Now we have to look into ensuring that there is equality, socio-economic rights are achieved. And I want to thank the Portfolio Committee for giving me this opportunity to present the budget vote and also the work that the Department of the Office of the Chief Justice has done. I also want to clarify, Honorable Horn, that even in the presentation to the Portfolio Committee, I was clear that the executive is now ready to now engage on the research that was done by the Judiciary, because we have also done our own research to be able to respond to the judicial governance and administration model. And maybe Honorable Horn might have missed it. I also said it now in this budget vote in the main speech that we are now ready and we are ready to engage and respond to the inputs that were made by the judiciary in terms of what a judicial administration.
Thank you, Honorable Minister.
Like, we will engage with them in terms of what is the view.
Thank you, Honorable Minister.
Of the executive.
Honorable Minister.
And protect the dependency of the judiciary. And I do believe that we'll be able
Honorable Minister.
To find each other in this engagement. Honorable
Minister.
Thank you very much. And thank you very much to all the members in the House.
Thank you very much, honorable members and honorable minister. That concludes the debate and the business of this virtual mini plenary session. The mini plenary will now rise, honorable members.
Thank you very much, Comrade Chair.